Have you ever tried explaining a legal brief to your dog and realized you understood it less than he did? That is basically what happens when regular folks try to read Board of Immigration Appeals rules without a map. Let us start with the boring but important part, the deadline. You usually get 30 days from the decision to file your notice of appeal, and missing it is like missing the last bus out of a town with no hotels. A brief is not just you yelling, "That is not fair," in fancy font. It is a structured argument that says, here is the rule, here is what the judge did wrong, and here is the proof. Legal error means the judge misapplied the law, like using a fork to eat soup. Maybe they used the wrong legal standard, ignored a controlling case, or skipped a required step in the analysis entirely. Factual error is different. That is, when the judge got the actual facts wrong, like saying the sky is green. Maybe they said your client missed a hearing when the record shows they were literally sitting in the room. Here is the plain truth. Nobody tells you at first. The BIA does not retry your case like a courtroom drama rerun. They review the record that already exists, so if evidence was not in the file the first time, it basically does not exist to them now. That is why the record is everything. More important than your opening line. More important than your fanciest legal word. If it is not in the transcript or exhibits, you cannot just wave your hands and pretend it happened. Think of your brief like a treasure map, except instead of 10 paces past the palm tree, you write, "See record page 212. Judges love pinpoint citations because it shows you actually read the file instead of guessing. A good structure usually goes like this: statement of the case, statement of the issues, argument, and conclusion. It sounds simple, but skipping structure is like showing up to a costume party in your regular clothes, technically present, not doing the job. Now here is a twist people do not expect. Tone matters even in legal writing. You can be firm and clear without sounding like you are yelling at a referee after a bad call, because calm precision reads as more credible than outrage. Let us talk about standards of review for 1 second, because this trips people up constantly. Legal questions get reviewed fresh, called de novo, while factual findings usually only get overturned if they are clearly wrong, so you tailor your argument to match which lane you are in. For AAO appeals, which usually deal with things like visa petitions, the approach is similar, but the agency and forms are different. Think of it as the same sport played on a different field. You still need to show legal or factual error, but you are following AAO-specific procedures and deadlines instead of BIA ones. A common mistake is repeating the same argument the judge already rejected, just louder, like reheating the same coffee and hoping it tastes different. New angle, new precedent, new record citation, that is what actually moves the needle. Preparation beats panic every single time in this process. Read the decision line by line, mark every questionable statement, then match each one to a specific piece of evidence or legal rule before you write a single argument sentence. If any of this made you go, "Wait, I need help with this," you are exactly why we do what we do. So if you want to learn more about our company, check out our links in the description.